Sometimes it just for me doesn't have a surface, but
What? All right. This honorable court's in session. May be seated.
For the record, calling number 2 and number 7 on today's list. Number 2 is the Commonwealth versus Aaron Hernandez on docket 2015-10384, and number 7 is the Commonwealth versus Aaron Hernandez on docket 2014-10417. Mr. Hernandez is present in court, represented by attorneys Charles Rankin and Jamie Selton, who have entered appearances on these cases. The Commonwealth is represented by ADA Patrick Hagan, Teresa Anderson, and Janice Smith. Your Honor, the 2015 case is before you for arraignment. The 2014 case is before you for status conference.
Counsel, why don't I see you while at sidebar for 1 moment? regard to the new indictment, what is received?
Your Honor, as to the 2015 case, may the warrant be recalled and the defendant be arraigned?
Get that.
Mr. Hernandez? On May 8th in the year of our Lord 2015, the grand jury for the County of Suffolk returned indictment 2015-10384, offense 001, charging witness intimidation. At this time, sir, do you wish to waive the formal reading of the indictment?
Yes.
And how do you wish to plead as to this indictment?
Not guilty.
You may be seated, sir.
Commonwealth, pursuant to our revisions to the domestic violence statutes, I must ask whether or not there is any domestic violence allegation relating to this new indictment.
There is not, Your Honor.
Very good. All right. With regard to the new indictment, do you want to be heard?
Yes, Your Honor. Relative to the new indictment, the Commonwealth is not requesting any additional bail based upon the fact that the defendant is now serving a life sentence and is held without bail on the underlying homicide cases before this court. That said, relative to the allegations and the indictment before the court now, the Commonwealth would state a brief factual basis for that indictment. The sole indictment before the court arises out of an extended grand jury investigation conducted by the Suffolk County District Attorney's Office, Boston Police Homicide Unit, with assistance of law enforcement officials in the area of Palm Beach, Florida. That grand jury investigation, on which an indictment was returned last week, May 8th, determined that on February 13th, 2013, in an area called Riviera Beach, Florida, the defendant, Aaron Hernandez, did shoot Alexander Bradley one time in the head. The evidence revealed that approximately 6 months earlier, Alexander Bradley had in fact witnessed the defendant to shoot and kill Daniel D'Abreu and Safira Furtado on July 16th, the year 2012, and injure a third man as the victims were stopped in a vehicle at the intersection of Shaman Avenue and Herald Streets in the South End. As far as the defendant was aware at the time, the investigation suggests that the defendant only knew that Alexander Bradley was the only eyewitness who could identify him as a perpetrator of that crime. Essentially, the investigation revealed that Alexander Bradley was a friend of the defendant, Aaron Hernandez, in 2012, that Alexander Bradley was present with Aaron Hernandez in the Cure nightclub when one of the victims, Daniel D'Abreu, bumped into Aaron Hernandez, spilled his drink. Mr. Bradley was a witness to all of the acts that happened after that, including Mr. Hernandez becoming angered as a result of what he perceived to be disrespect at the hands of Mr. D'Abreu. Mr. Bradley, the Commonwealth alleges in the course of this indictment, was present with Mr. Hernandez as he left the club in an agitated manner and then eventually got into his vehicle and left the scene. The Commonwealth alleges that Alexander Bradley was present in the vehicle alone with Aaron Hernandez when the vehicle pulled alongside the victim's car at approximately 2:30 a.m. at Shaman Avenue and Herald Streets in Boston. That Alexander Bradley directly witnessed as the defendant, Aaron Hernandez, extended himself to the driver's side of that vehicle, fired 5 times into the vehicle, killing Mr. D'Abreu and Mr. Furtado and wounding a third individual. Mr. Bradley was also present with Mr. Hernandez when that vehicle fled the scene. That vehicle was ultimately secreted at the defendant's cousin's house in Bristol, Connecticut. Relative to the indictment for intimidation of a witness, the Commonwealth investigation revealed that in the months following the homicides of July 16, 2012, the relationship between Mr. Bradley and the defendant changed somewhat, but did eventually normalize over time. The evidence suggests that during this time period, Mr. Bradley distinctly noticed that Mr. Hernandez became increasingly paranoid and fearful and concerned that law enforcement was watching or investigating him. The Commonwealth alleges that in February of 2013, the defendant invited Mr. Bradley, the victim, to a Super Bowl party in Florida. The evidence suggests that Mr. Bradley traveled there. They were staying together at a hotel. Mr. Bradley observed that one of the defendant's friends to handle what is described as a black Glock 40 or 45 caliber handgun, and that he saw the defendant handle this weapon. During the trip, the defendant, Mr. Bradley, and others went to a nightclub. The defendant saw 2 men at the nightclub. The defendant stated to Mr. Bradley that he thought these 2 men were undercover officers who were watching him. After pointing them out to Mr. Bradley, the defendant conveyed his belief to Mr. Bradley that these were individuals who were watching him. Mr. Bradley responded with words to the effect of, "It's probably because of the stupid stuff you did up there in Boston." At this time, Mr. Bradley noticed the defendant gave him a look and became visibly angry with him. The following night, Mr. Bradley and the defendant proceeded to another club in Miami. The group arrived at the club sometime after midnight. At the end of the night, Mr. Bradley and the defendant engaged in an argument based upon payment of the bill. They entered a car together. At that time in the car, there was a subsequent argument as well about a telephone that was left behind by Mr. Bradley. Mr. Bradley fell asleep during the car ride. When Mr. Bradley awoke to the car stopping in an alleyway, he awoke to find a handgun pointed in his face, that handgun being held by the defendant, Aaron Hernandez. Mr. Bradley was shot once in the face. That wound was a near-fatal wound to his face, resulting in the loss of his right eye, as well as a defensive gunshot wound to his hand. Mr. Bradley was then pushed out of the car. The car drove away. It's important to note again that the investigation determined that at the time of the shooting, as far as the defendant was aware, Alexander Bradley was the only person who could implicate him in the July 2012 homicides. The evidence suggests that that was the motive for shooting Alexander Bradley in the face, ultimately to kill him. Those are essentially the allegations, Your Honor.
With regard to those allegations, were any charges brought to law?
No, Your Honor.
Mr. Rankin, Mr. Sultan, understanding that what has just been said are merely allegations. Is there anything you want to say? I don't know.
There's been enough publicity without us adding to it.
As I understand it, Mr. Bradley has since cooperated with the Commonwealth in this investigation.
That is correct, Your Honor.
And with regard to his cooperation, has that been provided to the defense?
It has, Your Honor.
Is there any new discovery that you are providing today as it relates to the new indictment?
Yes, Your Honor. The Commonwealth turned over a voluminous amount of discovery today relative to the new indictment. I believe the only outstanding discovery relative to the new indictment is the last day of grand jury minutes from May 8, 2015. Those have not yet been transcribed.
And when will they be available?
I believe they should be available within 3 weeks, Your Honor.
And with regard to the pending case, we've had that on somewhat of a holding status while the case in Bristol County proceeded. The Bristol County matter now having concluded, it is time to get this case on track and aim towards a trial date. Is there any additional discovery to be provided with regard to the pending case?
I don't believe so, Your Honor. There is one motion, or I should say a notice that was filed today with the court, a copy provided to counsel for the defendant relative to DNA testing of the handle of the gun that was recovered relative to the homicide. That will be exhaustive destructive testing. The Commonwealth intends to go forward to that testing. We've given the defense an opportunity to have their own expert be present for that testing. It's the Commonwealth's contention that once the notice and opportunity to be present is given, that the Commonwealth can proceed with that DNA testing. We expect that we would have results within a month relative to the DNA testing on the gun.
Mr. Rankin or Mr. Sultan, did you receive that notice?
We did, Your Honor, and it's our position that once adversary proceedings have been initiated, as they obviously have here, that no destructive testing should be done without the courts ordering it. And I think if they file a motion showing that there's good cause to do destructive testing, we'll respond, and I think the court should properly rule on that motion. But we certainly object to their doing it unilaterally with or without a notice.
Well, it seems to me the Commonwealth can do whatever they want with the evidence that they intend to present, running the risk, of course, that if they do something that prejudices the defendant's right to a fair trial, that can come with a judicial consequence. But they have given you notice that they would like to do exhaustive testing. Have you engaged a defense expert with regard to DNA or forensic testing?
Your Honor, we have not, and if the court is going to allow them to do this, we do not intend to be there, in effect, to place a defense imprimatur on what they're doing. So we object to their doing it. We don't intend to be present if they're allowed to do it. The SJC has said, in the case that they cite, Gordon, that when the Commonwealth, quoting 422 Mass. 816 at 836, that when the Commonwealth performs testing that would exhaust the evidence, the better practice would involve careful documentation and photographing of the entire test. So hopefully they'll do that. But in any event, Your Honor, we object to their proceeding unilaterally without filing
where, Boston?
Correct, Your Honor.
Will the Boston Crime Laboratory do that destructive testing without a signed release by a defendant? I know some labs will not.
They do require an authorization form, yes, a release indicating simply that the defense does not wish to have an expert present.
Knock yourself out, seeing whether or not the defense will sign such an authorization. And if not, then I think you have to come before the court. See if I can help them.
Well, Your Honor, to save a step, we did prepare a motion just in case. In fairness to counsel, I don't believe counsel has seen our motion. It's very much the same language of the notice. But again, it's the Commonwealth's position that a motion is not necessary, but we would, again, to keep things moving in the case and not cause any unnecessary delay, we're filing now a motion for court order permitting exhaustive testing of a swab of the .38 caliber Smith & Wesson firearm. And it's attached with an affidavit from criminalist Amy Reynolds.
Mr. Sultan,
Well, Your Honor,
likely it's not a surprise, but are you surprised?
I'm surprised, Your Honor, that they had the notice in one pocket and the motion in the other pocket, since they knew yesterday what our position was. I would like a week to be able to respond to this, but I think this is exactly the right way to be proceeding, Your Honor.
All right.
And I commend them for doing it.
Why don't we do this? Why don't we set a filing date for any response? We can do that in 7 days and put this on for hearing perhaps 14 days out. Now, with regard to the case as you understand it, who am I addressing? Mr. Rankin or Mr. Sutton?
Depends on what you're addressing.
I'm going to address the scheduling of this matter going forward.
I'll address that, Your Honor.
All right. I know that you have been busy over the last several months, but it is time now to focus on this case. With regard to the discovery you have received, what are you contemplating by way of pretrial activity?
I think that we discussed with Mr. Hagan before the court came out, perhaps a discovery motion date in late July to give us a chance to finish reviewing the discovery that we had received, at the beginning of the Bristol County case in December, and the 3,000 pages or so that we just got today. So propose a date in late July for discovery motions and a date in late September for the filing of substantive motions. And then go from there with respect to a trial date once the court sees what is dispositive or substantive motions have been filed, and we have hearings on those. There are some transcripts from the Bristol County case that will be necessary for this case. Mr. Bradley testified in the Bristol County case. I think there probably are some other witnesses, but the only one I have in mind is Bradley.
Have you ordered that transcript?
The entire transcript has been ordered in connection with that appeal.
And have you spoken to the court reporters in Bristol about prioritizing?
She's away on vacation in May, but we will speak to her about getting Bradley done sooner rather than later.
Did I hear that 3,000 pages of discovery were provided today?
Is it 3,000? That sounds about right, Your Honor. Much of it is our phone records, hundreds of pages of phone records, much of which were just in the investigative phase. And also we provided numerous pages of prior redacted reports, grand jury minutes, things that we had to redact in a prior case based upon the open grand jury. Your Honor, if I may, it's the Commonwealth's position that while I agree generally with the scheduling suggestion from counsel, the Commonwealth's position is we would like a trial date set today. Obviously, if something happens that would necessitate it being moved, so be it, but I think it's in everyone's interest to block off a date. I think in light of the fact that the defendant was arraigned today on what you could argue is a Track A case with a 6-month date, that a November trial date, presumably for both matters, the Commonwealth filed a motion to join today. I know counsel objects to that, and that will be a litigated issue. but the Commonwealth would ask that we set a trial date in November, which I believe was the suggested trial date of counsel in a prior motion.
With respect to that, Your Honor,
Yeah.
November was open at the time we last saw the court, I guess in December. I now have a November 2nd federal trial scheduled that's going to go. It's a 2-week-long trial, so November is not available here. I'd suggest early January or February.
I'm sorry, I missed the federal trial.
I have a federal trial
Yeah.
scheduled to begin November 2. It's supposed to last 2 weeks, and it's a 3-defendant case. It's going to go.
Your Honor, the Commonwealth is open in September and October as well, and I do believe the case could be ready for trial in that time period.
Well, it seems to me it's appropriate that we try and resolve this case in this calendar year. But frankly, Mr. Hagan, if 3,000 pages of discovery is coming out today, it's understandable counsel's going to need some time to become familiar with that. I don't know that that necessarily takes us to late July, simply for a hearing on discovery motions, and then late September for the filing of any dispositive or evidentiary motions. What I'd like to do is this. I would like to put this case over 2 weeks, as we've talked about, for a hearing on the motion for exhaustive testing. I would like counsel to look at their calendars as to the ability to commence a trial in this case. I would like November, Mr. Rankin, if you're being held in the federal court, and they tend to be more rigid about their calendar than state courts, or at least more preemptive in access to counsel, then I would look at perhaps a late November or early December trial date. I don't like the idea of having a trial date driven by the pretrial life of a case. I think it makes more sense to schedule the trial date and then back up the pretrial activities to accommodate that date. And as I said, I think this case ought to at least start in this calendar year. So what I'm going to order is that counsel communicate over the next 2 weeks with your calendars as to what the earliest feasible trial date will be in either November or early December of this calendar year. And then, to the extent you all can agree on dates for either hearings on discovery motions or compliance dates, or hearings, the scheduling of any evidentiary motions to suppress, to dismiss, or motions to admit or preclude certain types of evidence, then I'd give you the freedom to propose those both hearing, filing dates and then hearing dates. And I'd like to see if 2 weeks from today we can cement those dates in a scheduling order to govern the future proceedings in this case. As to the motion for joinder, it would seem appropriate to hear that on 14 days from today. Understanding, Mr. Sutton, that you're contemplating a motion to dismiss, and it seems to me that wouldn't affect necessarily the joinder issue.
Well, Your Honor, certainly our review of the discovery, I think, would very much affect the joinder issue. So I would ask that the court not hear, to me that really is putting the cart before the horse. I mean, they allege in their motion, for example, that the evidence that they want to put in the new case would be admissible on the other case. We need to read what the discovery is to know what that evidence is before we're really in a position to respond intelligently to the motion. So I would ask the court to defer our obligation to respond to that motion until we've had a chance to read all the discovery we got today.
Well, see how much you can tell me in 2 weeks' time. It seems that the legal basis for joinder that derives from the fact claim to be interconnected sets of facts may permit you to have some intelligent position on it, understanding that once joined, they could be severed at some point in the future if indeed the factual connections are not there, and understanding as well that your right to pursue a motion to dismiss would lie as to that new indictment almost at any time.
May we address that orally, Your Honor, in 2 weeks, as opposed to having to file a written opposition by then?
If you feel that you can orally articulate your grounds, I'm sure you can. That's fine.
Thank you.
All right, is there anything else we should focus on today?
No, Your Honor.
I think I'd like to waive Mr. Hernandez's appearance until it's necessary at an evidentiary hearing, so we don't need him here at the next hearing.
And that's your view, even if we discuss the joinder issue?
Correct.
Very good. And Mr. Hernandez is excused from the next court date. 2 weeks from today. Mr. Sullivan, Mr. Rankin, if you could have something filed 7 days from today as it relates to the DNA issue. We will testing, and we'll set that up for hearing as well as the motion to join and the issuance of a scheduling order for June 4 at 2 p.m.
Resolution 2014-10417. This matter is continued by agreement to June 4th, 2015. In this session, courtroom 906 at 2 p.m. for hearing on Commonwealth's motion for exhaustive testing and joinder and status for a trial date. Mr. Hernandez's appearance will be waived on that date. And as the 2015-10384 case, as to bail, the court orders you to recognize personally without surety in the sum of $100 for your further appearance before this court. You are notified if you are charged, you're notified that if you are charged with, you are notified if you are charged with a crime during the period of your release on this recognizance. Recognizance may be revoked in accordance with General Law, Chapter 276, Section 58. This matter is continued to June 4th, 2015, in this session for a pretrial conference. Presence will also be waived by the attorneys on that date. Thank you, Counsel.
All right.
This will go to the pile of crazy nonsense.
Court stands for a brief recess.
These are our files. The original, our copy of what is filed. Tell Rourke I'm on my way.
Denise.